take this to its logical conclusion.
Okay, let's
using
do this.
the model
Yes.
that we have set up
Yes.
under the Supreme Court majority.
Yes.
The president does speak to the military. The military does control SEAL Team 6.
He doesn't understand the ruling. He's making the mistake that to overcome the presumptive immunity, you have to show that the action was really bad. That's not the test. Yes! Yes! Holy sh! You can't probe into them. You can't cite them for anything else. I can't criminally indict them for that. I can't even use that as evidence towards another crime, which is going to be relevant for obviously for Trump's criminal prosecutions.
So the Supreme Court starts its decision by defining the crimes for which Trump is being charged. And they essentially break them down into 5 categories. 1, he tried to get state electors to change their votes. 2, he organized fraudulent state electors. Now, all those things
I'm so curious.
Of course, not all of the president's official acts fall within his conclusive and preclusive authority. Taking into account these competing considerations, we conclude the separation of powers principles explicated in our precedent necessitate at least presumptive immunity from criminal prosecution for a president to act within the outer perimeter of his official responsibility. Why? Well, because she's a militant left-winger.
Oh boy. These are my full takes on the recent Supreme Court case that was just ruled on July 1st, in which Donald Trump is bringing a case before the Supreme Court seeking some forms of immunity from criminal prosecution for at least things that he considered to be official acts of him as the president. That's what his counsel was arguing in front of the Supreme Court. A lot of people are talking about this, probably people who either haven't read it or don't understand it or have, some agenda that they're interested in pushing about it. But regardless, here's my reading of it, of which we've spent the last 3 days painfully going over the entire decision. Chief Justice John Roberts, writing their majority opinion, argues that the president has 3 different types of actions that he can take and then creates a novel ruling about the types of criminal immunity that would apply to the president based on the kind of action that he's taken. For these actions and for the criminal immunity that's been granted for these actions, this is a new thing that has never been done in the history of the United States. As far as I'm aware, as far as anybody else pointed out, for basically any citizen ever at any point in time. The idea that there would be absolute criminal immunity for some action has never been discussed in the history of the United States, not for the president or anybody else. Roberts is going to make a ton of citations to a case relating to, I think it's Nixon v. Fitzgerald or Fitzgerald v. Nixon, that has to do with suing the president for having an airline official being fired, basically. We're only talking about preventing the president from being sued for, by private citizens, civil matters. So the 3 buckets that John Roberts basically groups actions into are, we have core powers, which are actions that these actions are not only beyond judicial review, none of these acts are able to be cited or referenced in any other criminal matter as evidence or otherwise. So if Donald Trump is performing some action that we consider to be conclusively and preclusively within his role, so for instance, conversations between him and his officers, like the heads of his departments, these things would be beyond all criminal review. You can't probe into them. You can't cite them for anything else. So for instance, let's say that we knew that Trump said, I'm going to fire you unless you do XYZ criminal act. I can't criminally indict him for that. I can't even use that as evidence towards another crime, which is going to be relevant for obviously for Trump's criminal prosecutions. But the core powers here that are conclusive and preclusive to the office of the presidency, Roberts has said that these are given absolute immunity from all criminal prosecution. But the second bucket that he's got, he calls these things official acts. So official acts are actions that the president takes up, that are up to the outer perimeter of all of the things that a president can do, as long as it relates to the effective discharge of a president's powers. So any action that's declared to be even in the outer perimeter of what a president might do as an official act are given presumptive immunity in order to protect the president's ability to execute the duties of his office fearlessly and fairly. I think that if you just imagine historically how the United States was founded, the idea of creating an executive who is beyond criminal prosecution is kind of silly. Obviously, none of the framers had this in mind. We just rebelled against a king. Why would we make another one? This means that the burden is on the government to argue that applying a criminal prohibition to that act, or I should say, I'm sorry, that engaging like a criminal investigation of that act, the government has to argue that that investigation would pose no dangers of intrusion on the authority and functions of the executive branch. There cannot be any danger whatsoever for the president to perform his job. So if you're doing an investigation, even if you think he might have done some criminal act, if that investigation risks damaging his ability to perform any other act, if you can't prove that there would be no risk there, that action is also given immunity. One thing that's important too when we think about this type of immunity that's being granted, this immunity is not like a defense that one would use in court, or it's not a defense that you would use on appeal. This is like a thing that comes before any court action has even happened. Those are official acts. Then the third bucket are things called unofficial acts. These are actions that the president takes essentially as a private citizen. I mean, he could take these actions as president, but they're just unofficial acts. They have nothing to do with his job as president. And obviously, Roberts says that for unofficial acts, there is no immunity. Now, unfortunately, we are given absolutely no guidance nor examples for what a private act might be or an unofficial act might be. Roberts notes that in dividing official from unofficial conduct, courts may not inquire into the president's motives. So when you're doing investigations and you're trying to separate an official act from an unofficial act to figure out, was the president operating in his capacity here? For instance, let's say when he gives a speech, he could be acting an official act or unofficial. You cannot consider the president's motivations when you're trying to figure out whether or not this would fit the official or unofficial act. A lot of the people that are talking about this opinion are trying to say that, oh, well, you know, he only gets immunity for core powers. That's great. And unofficial acts obviously can still be indictable and can come under judicial review in the criminal justice system. But what all of them are skipping over is the idea that the official acts presumptive immunity could be unfathomably broad. So conversations between Donald Trump and his acting attorney general with regards to sending fake letters. He essentially said, he said, you need to send letters to states and you need to tell them that we have, good reason to believe that there's been voter fraud, that the department is investigating these things and we found evidence of it. He was telling his attorney general, you need to lie and send these letters. And if you don't, I'm going to fire you. Because this is under the exclusive role of the president, these are conclusive and preclusive powers. The president gets to decide, who to fire, who to hire, and it's a core power of the presidency, right? That entire conversation is considered absolutely immune. That means that not only is anything that he said in that conversation completely not criminally indictable, it cannot be used as evidence in the furtherance of any other crimes. But the conversations between Trump and Pence, with regards to Trump trying to pressure Pence to flip the electoral votes, even the alleged conduct here would be presumptively immune because it is within the roles for the president and the vice president to speak to one another. Now, 3 and 4, these buckets of actions that he's talking about. The first is communications with state officials with regards to their electors, calling them and saying like, hey, you guys need to toss your electors. You need to change your votes. We think that there was voter fraud. This was completely remanded to the lower court saying you need to figure out which of these actions were official versus which actions were unofficial. Roberts gave absolutely no guidance for figuring out what was official or unofficial. And then on the fourth point, Trump's speech and actions that he made on January 6th in regards to the ongoing insurrection, that was remanded to the lower courts to figure out which actions here were official or unofficial, with no guidance given for figuring out which ones were official and which ones were unofficial. The one thing I don't like is that Roberts never addresses a single time what about the state or the people's interest of not having a crime-committing president. That is never brought up a single time. He never considers the public interest of not having a crime-committing president. So a lot of people I've noticed, and we'll get into some writing about this, a lot of people are saying that, oh, well, actually, at least the court didn't go as far as what Trump's lawyers wanted. Trump's lawyers were saying that, well, if you want to criminally indict a president for official acts, at the very least, you have to impeach him first. Roberts has not said that if you're impeached for a particular thing, that you can now be held criminally liable for it. He says that impeachment clause makes no statement as to what types of crimes can the president be indicted for. I feel like Roberts should have remanded the Trump and Pence conversation back to the district court and granted it. He would say, oh, it's probably got presumptive immunity. Same thing with the conversation between him and his attorney general, but he didn't do that. I don't know why he made a declaration on one, but he didn't declare anything obviously private or obviously unofficial acts. And then Justice Ketanji Brown, dissenting, writes that while Roberts expresses great concern about the separation of powers that he, while Roberts writes a great concern about separation of powers, Roberts obsesses over this idea of separation of powers, because every single time you charge a president with a crime, obviously the president's going to challenge, well, this is official conduct, you can't probe this, and all of those decisions are going to make their way up to the Supreme Court, most likely, and the Supreme Court is essentially going to have the final say over whether or not a president is ever breaking a crime. So they've snatched that criminal enforcement from the legislature, which one might argue is a more severe form of upsetting the balance of power than simply saying that the president should probably be able to be held criminally liable for their actions. A lot of people are saying that, people are being unhinged with their evaluation of the opinion. I don't think people are being unhinged about this. I think that if we weren't worried about like a Navy SEALs assassination hit jobs on fellow politicians, I don't know why Roberts wouldn't have just addressed that